Welcome to the National Healthcare Associates Annual Compliance Training. We conduct this training each year so staff understand our compliance program and how to conduct ourselves in an ethical and compliant manner. We appreciate your time today and thank you again for all that you do. If you have any questions following this presentation, please do not hesitate to contact your supervisor or administrator. Please note that at the end of the presentation, you will be asked to complete a short quiz to demonstrate your understanding of the material. So without further ado, let me provide you with a brief overview of what we will discuss today. First, we will discuss the various elements of our compliance program. We will then go over the code of conduct, including a discussion of fraud, waste, and abuse, as well as proper business practices. We will then spend time on HIPAA privacy and security. So let's first talk about our compliance program. National Healthcare Associates and its affiliated facilities have a robust compliance program, which purpose is to ensure that we operate and carry ourselves in accordance with applicable laws and regulations. The goal of the program is to prevent, detect, and correct any violations of law or the code of conduct. It is your responsibility to understand the compliance program, report any suspected violations, and participate in any compliance activities, including annual training. The compliance officer has the responsibility to build and maintain a culture of compliance, prevent, detect, and respond to compliance concerns, and prevent retaliation and retribution against those who report potential violations. There are 8 elements to the compliance program. First, we have a compliance officer who oversees the compliance program. We then have policies and procedures, including the code of conduct, which guide us in maintaining a culture of compliance. We have open communication through the use of a compliance hotline, which staff can use to report any good faith compliance concerns without fear of intimidation or retaliation. When there is a valid concern, we promptly respond and correct such concern. We will use discipline when necessary to enforce our policies and procedures. The last 2 elements include regular compliance training and auditing to identify and correct any potential compliance concerns. As mentioned, the first element of the program is the compliance officer. Your compliance officer is the administrator of your facility. It is your responsibility and obligation to notify the compliance officer of any potential violation of laws or code of conduct. This includes behavior that limits or restricts our ability to serve residents and their families, behavior that is not in accordance with laws, and suspicious behavior. There are 4 primary ways to report concerns. First, you can notify your supervisor, administrator, or compliance officer. You can call the compliance hotline at 888-345-0079. You can email compliance@nathealthcare.com, or you can document your concern by accessing the facility website and clicking on Report a Compliance Issue. Please know that this is the only true anonymous way to report a compliance concern. It is prohibited for any workforce member to engage in retaliation, harassment, intimidation, and/or retribution of any kind against another workforce member who reports a compliance concern. If you ever feel that your position is threatened as a result of your reporting of an actual or potential compliance concern, please immediately contact the compliance hotline at 888-345-0079. Now that we have gone over the compliance program, it is time to discuss the code of conduct. The code of conduct sets forth principles and guidelines which we must follow in order to maintain a compliant culture. To put it simply, the code of conduct guides us in doing things the right way, ensures that we provide quality care and respect resident rights, and that we report any concerns that may violate the code, laws, or facility policies. These are just some ways to ensure that we provide quality care. Timely completion of assessments and interdisciplinary care plans, provision of individualized treatment and services to address residents' needs, accurate dispensing of medications to and monitoring of residents, reassessment of outcomes to measure and confirm quality care goals, and accurate documentation of our interactions with residents, their families, and visitors. This list is by no means exhaustive. We must be committed to working together to provide residents with the quality of care they deserve. In respecting resident rights, we must protect residents from verbal, physical, emotional, or sexual abuse or neglect. Treat residents with courtesy, respect, and dignity. Ensure residents participate in their healthcare decisions, and ensure residents are not improperly denied care. According to Section 483.12, all residents have the right to be free from abuse, neglect, misappropriation of resident property, and exploitation. This includes, but is not limited to, freedom from corporal punishment, involuntary seclusion, and any physical or chemical restraint not required to treat the resident's medical symptoms. Abuse is the willful infliction of injury, unreasonable confinement, intimidation, or punishment with resulting physical harm, pain, or mental anguish. It includes verbal abuse, sexual abuse, physical abuse, and mental abuse, including abuse facilitated or enabled through the use of technology. Abuse also includes the deprivation of goods or services that are necessary to attain or maintain physical, mental, and psychosocial well-being. Neglect is the failure to provide goods and services to a resident that are necessary to avoid physical harm, pain, mental anguish, or emotional distress. Exploitation means taking advantage of a resident for personal gain through the use of manipulation, intimidation, threats, or coercion. We must immediately report to the state any alleged violations of abuse, neglect, exploitation, or mistreatment, including injuries of unknown source and misappropriation of resident property. We must report allegations of abuse or serious bodily injury within 2 hours and no later than 24 hours for other alleged violations. Misappropriation of resident property is the deliberate misplacement, exploitation, or wrongful, temporary, or permanent use of a resident's belongings or money without the resident's consent. In order to prevent misappropriation, we must take an accounting of residents' possessions upon admission, offer safekeeping for valuable possessions, and offer resident fund accounts. Drug diversion is not only a form of misappropriation, but it is also illegal. We'll report anyone who has diverted to the appropriate authorities. If you know of anyone diverting drugs and medication, you have an obligation to immediately report it to your compliance officer and/or the compliance hotline. At this time, it is important to remind you that it is strictly prohibited to use, distribute, or be in possession of any illegal substances. Abuse or any unauthorized distribution of facility drugs is also strictly prohibited. Any violators of this rule will be subject to discipline up to possible termination. Finally, at National Healthcare, we never discriminate, exclude, or treat others differently based upon their race, color, nationality, age, disability, gender, history of mental disorder, marital status, or sexual orientation. Now let's discuss laws and rules related to fraud, waste, and abuse. First, some definitions. Fraud is the making of material false statement or representations of facts an individual knows or believes to be false in order to obtain payment or benefit to which we would otherwise not be entitled. An example of this would be billing for services that were not rendered. Abuse is a practice that directly or indirectly results in unnecessary costs or improper payments for services which fail to meet recognized professional standards of care. For example, providing patients with substandard care. Waste is the overutilization of services or practices that result in unnecessary costs. Waste occurs when there is a continuation of therapy that is no longer medically necessary. The primary laws we are concerned with related to fraud, waste, and abuse are the Federal and State False Claims Acts, the Anti-Kickback Statute, and the Stark Law, or Physician Self-Referral Law. Under both state and federal False Claims Acts, it is unlawful to submit claims for payment with false and untrue information. Civil penalties for violations of the Federal False Claims Act can be anywhere between $5,000 and $11,000 per violation, plus trebling of actual damages. In order to ensure that we never violate the False Claims Act, we are expected to submit accurate and truthful claims, ensure sufficient documentation to substantiate claims, refund any overpayments, accurately report financial transactions, and alert your supervisor or compliance officer if you become aware of a false or questionable claim. It is important to know that while we recommend that you bring any evidence of false claims to your supervisor or compliance officer first, under the False Claims Act, you may instead bring a qui tam action on behalf of the government against your employer up to 6 years after the alleged violation. The government may choose to intervene in the action and assume primary responsibility. Qui tam relator may be entitled to 25 up to 30% of the recovery of the lawsuit if successful. The anti-kickback statute renders it unlawful to offer or accept kickbacks. Kickbacks are any items or services of value known as remuneration, including cash, goods, gifts, freebies that are received in return for the incentive or acceptance of referrals or business. A person who violates the anti-kickback statute may be subject to prison time, large fines, and program exclusion. Workforce members may never ask for, accept, offer, or give kickbacks of any kind. The Stark Law, or Physician Self-Referral Law, prohibits physicians from referring Medicare patients to entities for designated health services if the physician, or his or her immediate family member, has a financial arrangement with the entity. Now let's briefly discuss some proper business practices. First, we credential and perform exclusion screening on all prospective employees and vendors before entering into an employment or contractual relationship. We will not knowingly hire any employee or retain any vendor that is unqualified or has an invalid license or certification. The employee or vendor must also not be disqualified from participating in any federal or state-funded healthcare program. We will thereafter screen on a regular basis to ensure that they will have not subsequently been debarred or excluded from a government healthcare program. Furthermore, employees must avoid arrangements, business dealings, and agreements with vendors, independent contractors, or those seeking to do business with your facility, which may create a conflict of interest. That is, the relationship affects your allegiance to the facility. Before entering into such an arrangement, you must first seek approval from administration. Also, please be advised that employees may not use any company property or resources or disclose company information for their own personal benefit. Finally, sexual harassment or abuse of residents and employees is strictly prohibited. If you observe anyone engaging in such activity, contact your supervisor, compliance officer, or administrator immediately. You can always report such matters to the compliance hotline by phone at 888-345-0079, by email at compliance@nathealthcare.com, or anonymously on the facility website. For the remainder of this training, we will discuss HIPAA privacy and security. HIPAA, the Health Insurance Portability and Accountability Act, sets the standard for protecting sensitive patient data, known as protected health information. HIPAA establishes rules and limits on who can access and receive protected health information, also known as PHI. The HITECH Act, Health Information Technology for Economic and Clinical Health, sets forth rules for how electronic PHI is stored and used. There are 4 main rules of HIPAA and HITECH. There's the privacy rule, which addresses the use and disclosure of PHI by covered entities and business associates. Then there's the security rule, which addresses the security and protection of PHI held or transferred in electronic form. This rule sets the technical and non-technical safeguards that must be in place to secure ePHI. There's also the breach rule. A breach is the unauthorized acquisition, access, use, or disclosure of PHI in a manner which compromises the security or privacy of the PHI. The breach rule requires notification following a breach of unsecured PHI. Lastly, there is the enforcement rule, which addresses compliance and investigations and sets penalties for violations of HIPAA. These rules set forth the guidelines for disclosure, use, and security of PHI, and what to do if PHI is breached. Let's be clear on what PHI is or can be. PHI can be individually identifiable health information, such as Social Security number or date of birth. PHI can be oral or written on paper or electronic form. It can be created or received by a covered entity, and it can relate to past, present, or future healthcare or payments. Here's a list of certain PHI identifiers, including address, phone number, and medical record number. It is important to know that a PHI identifier can be any information that links medical information to a patient. The information does not necessarily need to contain the patient's name or Social Security number. It can even consist of unique numbers, codes, or characteristics. There are two instances when disclosures of PHI are required: at the request of the patient or an investigation into compliance. Disclosure of PHI is permitted for treatment, payment, and healthcare operations. In response to a valid authorization for reports of abuse, neglect, or domestic violence, and for judicial or administrative proceedings or law enforcement purposes. Some common HIPAA violations are leaving computer screens with the chart open for public viewing, discussing residents in common areas such as elevators, lobbies, or hallways, sending unencrypted texts or emails, leaving papers containing PHI on a printer, and emails containing PHI sent to unintended recipients. Please be advised that photography or recording, audio or visual of any kind in patient care areas is strictly prohibited. Be further advised that no one, including staff and workforce members, may post photographs or videos of residents or resident PHI on the internet or social media without express written authorization of the resident. Common social media breaches include posting information about patients without express written authorization, even if their name is left out, sharing photos of patients, medical documents, or other personal information, accidentally sharing any of the above while sharing a picture of something else, and assuming posts are deleted or private when they are not. Here are 4 ways to promote HIPAA privacy. Keep hard copy PHI, such as medical records and billing statements, in a secured location. Use reasonable precautions when communicating with residents through the mail, phone, email, text message to avoid disclosure of PHI. On the EMR, make sure to close out the chart when finished, and do not take photographs or video in patient care areas. When using or disclosing PHI, we must follow the minimum necessary principle. This ensures that reasonable efforts are made to limit use, disclosure of, and requests of PHI to the minimum necessary to accomplish the intended purpose. The question you want to ask yourself is, do I have a business need to know? In treating residents, we may at times use the services or products of business associates. A business associate is an entity or a person who transmits, uses, or discloses PHI on behalf of the facility known as a covered entity. For example, National Healthcare Associates is a business associate of your facility. A business associate agreement is an agreement between the facility and a business associates that establishes permitted uses of PHI, obligations for safeguarding PHI, and reporting non-permitted uses or disclosures of PHI. There must be an executed business associate agreement with each vendor or contractor that uses and discloses PHI on your facility's behalf. As a reminder, we must never respond to or click on any links in phishing emails. Phishing emails trick users into revealing sensitive information. Phishing emails can look legitimate, but they are not. Never disclose usernames or passwords, social security numbers, or sensitive information via email or email links. Phishing emails led to a significant increase in security breaches over the last year. If you receive a suspicious email, please let your supervisor, compliance officer, or compliance hotline know as soon as possible. The HHS Office for Civil Rights enforces HIPAA and conducts investigations of possible violations of HIPAA. There are potentially significant civil, monetary, and criminal penalties for violating HIPAA, including $100,000 to $50,000 per violation, $25,000 to $1.5 million per violation if several similar violations occur in a calendar year, and possible prison time. Finally, if you receive a privacy or security concern, please let your compliance officer know as soon as possible. You can also contact the compliance hotline at 888-345-0079 or compliance@nadhealthcare.com. Complaints will be promptly investigated and the appropriate parties' agencies will be notified. Thank you for your time today. We ask that you now complete the short quiz. If you have any questions about today's presentation, please contact your supervisor, compliance officer, or compliance hotline. Thank you.